All right, it is 10 o'clock, so I'm going to go ahead and get started while we have a few more people jumping in. This is Diana Kelly, President and CEO of Camp Cal Now RV Park and Campground Alliance. For those of you that don't know who we are the association in California that represents all the RV parks and campgrounds. Been very busy these last couple of years, keeping everybody open and operating. And in lieu of our in-person convention, we started this webinar series that has been incredibly successful and something that I think we will continue. Dan Rudderow from the Rudderow Law Group and I have gotten together to produce several of these presentations for you, and we hope that everyone finds them as valuable as we believe they are. Once we get through this presentation, there will be a poll at the end. Please stay for the poll because it really does help us create more programs to benefit our members. Today we have Dan Rudderow, and Dan is our lead attorney partner for the Legal Hotline program. His law firm represents owners and managers of RV and MH communities throughout California. And his practice includes preparing rental agreements, park rules for communities, assisting with day-to-day management and operational issues, which we take those calls pretty frequently. And his firm also represents park communities in litigation, including eviction and rent control cases. Dan has authored several articles in the manufactured housing industry publication and is an advisory board member of the MHET. Thank you, Dan, for joining us. In addition, we have Andrew Wertheim, and he achieved his Juris Doctorate from Chapman University, Fowler School of Law in 2011. And Andrew is a patented inventor and enjoyed part ownership in 3 companies prior to opening Pacific Estate Planning. Andrew is highly respected amongst his colleagues and is regularly hired by prominent law firms to assist them with a variety of complicated matters. His primary practice areas are estate planning, entity formation, business annual compliance, and business succession planning. So we're excited to be able to bring this presentation to you guys. We also have Zebulon Law. Zeb earned his bachelor's degree from Long Island University, and he went on to receive his JD from the American University Washington College of Law in 1988, and a Master of Laws in Taxation from Georgetown University. In addition, Zeb is a licensed CPA and has practiced law in Orange County since 1993. His practice includes estate planning, business planning, tax planning, and trust and probate administration matters. Over his career, Mr. Law has utilized his extensive knowledge and experience in tax and estate planning to implement advanced techniques that have resulted in millions of dollars of estate and gift tax savings for numerous high net worth clients. And so I'm very pleased to introduce all 3. And Andrew, with that, I will let you take it away.
Thank you very much for the wonderful introduction. It's very nice to meet everyone. Please take a moment and write down my email address, which is at the bottom of the slide. It's andrew@pacificestateplanning.com. If I do my job right today, you'll be left with some very important questions. I want to make sure I'm available to get you those answers. So please feel free to use the Q&A today during the presentation, but also you can email me at any time. Now we have a lot of ground to cover, so we're going to get right into it. First, the typical lawyer disclaimer. None of the following is legal advice. These are expressions of opinion only. And by listening to this video, we are not forming an attorney-client relationship. I make no guarantees or warranties. Please do not use the information here to represent yourself. Always seek the guidance of an attorney. Now, so you can put a face to the voice, this is me. I did graduate from Chapman back in 2011. I'm a patented inventor, and I've been a business owner for 13 years. I've been practicing as an attorney for around 3 years. This is my colleague, Zeb Law. Zeb, would you like to talk briefly about yourself?
Yeah, sure, Andrew. Thank you. And thank you, Dan and Diana, for giving both Andrew and I the opportunity to speak. Diana summarized my background, but I've been doing estate planning here in California since 1993 and have many mobile home park and RV clients. And I'll jump in from time to time, throughout the presentation.
Wonderful. Thanks, Zeb. I want to just highlight, Zeb and I make a rather excellent team. And the reason why I think you need both of us, Zeb has been practicing for 30 years. All of us, myself included, can benefit from his wisdom and life experience. But the reality is most of your estate plans will not become effective for another 20 to 40 years from now. I'm in my mid 30s. I have another 40 to 50 years left in my career. So we kind of get the best of both worlds. We get Zeb's wisdom now, and then you get me who will still be here and will still be around when these plans become effective. And that's why I feel we're a really wonderful team for you. Now to jump into the substance, almost daily I get asked, Andrew, what is an estate plan? And at its core, an estate plan asks and then answers these questions. When you get sick, injured, grow old, or pass away, who will raise your children? Who will run your business? Who will inherit from you? At what ages and under what terms? And most importantly, when you're sick or injured in the hospital, who will be there? Who will be there to protect you and possibly save your life? I feel we all deserve to have a friend or family member there to advocate for our rights at the hospital. And an estate plan is designed to do that for you. Now, today we're going to talk about probate court savings and advanced tax savings and liability protection and all sorts of advanced planning. But before we get into the bells and whistles, I just wanted to pause and highlight the basics and ask, what is the point of having companies and financial assets if you're not around to enjoy them? Estate planning is about preserving your wealth and leaving it for the next generation, but I am far more interested in protecting you. If you do not have a basic estate plan yet, including an advanced healthcare directive and HIPAA waiver, I want you to email me today. Zeb and I can help you. And again, that email is andrew@pacificestateplanning.com. Now, an estate plan consists of these 5 documents. There are some ancillary documents too, but these are the major ones. A will nominates guardians for children and will pour assets into a trust if necessary. A trust will choose who inherits from you, under what terms and at what ages. It avoids a probate court proceeding. It ensures a high degree of privacy, and it offers both tax savings and creditor protection. And we'll go into the specifics of probate in a moment, but essentially it's a 1 to 5 year public court proceeding where after you pass away, someone has to determine who inherits from you. And that's the goal of that court. A trust will bypass that court process entirely.
Sorry, Andrew, I'll just jump in for a second because we're going to talk about funding at some point, but I find this with some mobile home parks and RV parks. You want to look closely at the titling of the mobile homes, if the park owns any of them, and the title of RVs and the like, because if those things aren't handled properly, some of those are obviously going to be, in the names of tenants, but titling on those things can be a little tricky, and we've had some client situations over the years where those weren't titled correctly, and it resulted in probates.
Very good point. Absolutely. A trust is only effective for you if your assets are actually in the trust, which we will go through in further detail soon. The other 3 documents of an estate plan protect you during your life. We rarely just pass away. Typically, we experience either a physical or a mental incapacity. Mental incapacity is easy to picture, Alzheimer's or dementia. Physical incapacity, I just had a client who is in a skilled nursing facility with a broken leg and COVID. Mentally, she's 100% here, but she physically couldn't leave to get her checkbook. That's where having a financial power of attorney really helped her. So there's both types of incapacity. And these 3 documents, the financial power of attorney, advanced healthcare directive, and the HIPAA waiver, are designed to help you recover from that injury and make sure that you have a life to get back to once you do recover. So more specifically, the financial power of attorney, this authorizes someone to open your mail, pay your bills, and run your company during a time when you can't do it yourself. It literally gives someone the power to sign your name for you. I want you to think to yourself for a moment, when was the last time you signed your name? Could have been on a check, could have been a contract or some other document. what would have happened if you couldn't sign and no one was authorized to sign for you? I know as a business owner, this scares me. Could you pay your employees? Could you pay your bills? Hire new vendors? Can you enter into new contracts? How would you hire an accountant to do taxes for you? Or hire an attorney to defend you in court? I will tell you, as an attorney, I am not supposed to represent you in a matter exceeding $1,000 unless I have a signed contract with you. Well, if someone's suing you and you can't sign my contract and no one's legally authorized to sign for you, what do? We'd have to go to court and have the judge essentially sign for you, which is very expensive. The financial power of attorney is going to prevent that from ever happening and have someone legally authorized to help you if you need them to. All right, so if you're a business owner, you need an estate plan because otherwise your entire business can be put on stall. Now that we've established how valuable you are, the Advanced Healthcare Directive will nominate friends or family members of yours to make medical decisions for you if you can't do that yourself. If you're unconscious in that hospital bed, who do you choose to choose your doctors for you, or choose your hospital or your surgery or your medicines or any other healthcare decision? If you want to choose who this person's going to be, you need a healthcare directive. Then finally, the HIPAA waiver. Our health information is protected by federal law, even from our own family members. It can be protected even from your own spouse. You need this document to authorize those you love to learn your medical information so they can make decisions for you and then help you if you're not able to help yourself. It should be a separate document. It should be in size 14 font or greater. There are very particular rules because you want it to comply with both federal law and California law. There are two sets of laws that apply. And in my practice in particular, I just keep finding this form either missing or done improperly. So if there's any doubt in your mind, please email me. Let me look at it. And with that, let's get to the fun financial information. So again, if you pass away and you don't have a trust, then we're going to go to probate court. Or I should say your family will be forced to go to probate court. And probate court is a public court proceeding. It can take 1 to 5 years, and it's used to determine who will inherit from you, because if you don't decide that, someone has to, right? If you pass away without a will, then California will decide that for you. If you pass away with a will and it's done properly, you get to choose, but you still pay all the probate court expenses. Whereas if you have a trust, you get to choose with great specificity and the guidance of an attorney, and you avoid these fees entirely. And so what fees am I talking about? Well, if you have a $1 million estate, think the value of your house, the value of your company, your investment assets, the cash in the bank, and various other things. Most of you are going to have more than $1 million. But let's say you had a $1 million estate. You should expect to lose $46,000 to the probate court unless you have a trust. If you have a $5 million estate, you should expect to lose $126,000 to the probate court unless you have a trust. The law does care.
Hey, Andrew, sorry, I'll jump in for a second too. I just want everybody to be clear that those are based on gross values. So you could have a $5 million mobile home park with $4,999,000 of debt, and your fees will be $126,000 because they base probate fees on gross values, not net.
Yes, the law does not care about any liens or mortgages that you have on the property. They want the fair market value. That's how they determine the fees. And then you should also add $3,000 to $3,500 on top of this, because you have to pay court filing fees, probate referees, newspaper publication fees. It's very expensive. A trust will bypass pretty much all of it. It'll let you transfer your assets to who you want per your terms. And then there's advanced tax planning that can be used. So the above fees, the $46,000 or the $126,000, that is for probate court only. That is separate from any taxes that you may incur. A good estate plan is going to offer counsel regarding estate taxes, gift taxes, capital gains, and state property taxes, among others. And that's where it's very important to hire an estate planning attorney where this is all that they do, because otherwise a lot of this gets missed. I've had a lot of requests lately to talk about the current tax landscape and then what the current proposals are. Um, and at the moment, what we have right now is we have what's called an estate tax. So when this is a tax that triggers at death, and currently it's a 40% tax rate. We have a gift tax, which is taxed during life. And again, it's a 40% tax rate. And at the moment, it's unified. So we have $11.7 million per person that's excluded, or $23.4 million for a married couple. All right, let's break this down a little bit. What does it mean? So estate tax happens after you pass away. Gift tax happens, let's say you gave a house to a child today. That the value of the house would be attributed to a gift tax. And then it would be that exclusion would be added to any property that you give to somebody at death. It's unified. In addition, we have a capital gains tax where we're taxed on the profit made from a sale. So if you bought a house in 1970 for $400,000 and today it's worth $1 million and you were to sell that house today and it was an investment property so that IRC 121 doesn't apply, then we would have a $600,000 profit and you would be capital gains taxed on that $600,000. Probably you would lose around 20% of that $600,000 profit. But there's such a concept called a step up in basis. If instead of selling the property during your life, you wait to pass it down to the next generation, then at your death, all of that profit will essentially be forgiven. And your child, let's say, instead of inheriting a property with an assessed value, a base value at 400,000, will inherit at $1 million. So if they sell it the next day at $1 million, there will be no capital gains tax at all. So it's important to meet with an estate attorney to kind of weigh the pros and cons. Do we want to sell this during your life, or can we pass it down to the next generation?
Hey, Andrew.
Yeah.
So this is Zeb. I'll jump in for a second there too, just so people are aware that estate tax and gift tax are based on net values. So if you have a mobile home park worth $10 million, let's say, but there's $8 million of debt on that, the estate and gift taxes are generally just on the $2 million of equity that you have on the property. And the capital gains tax step up is often really important for mobile home park and RV park owners to get that step up. So because up to that 11 million, if you pass away, your kids can sell the mobile home park without any capital gains tax. I just wanted to jump in there to explain that.
Thank you, Zeb.
Hey, Andrew, I also we had a question come up, but I just wanted to let everyone know we will be doing Q&A at the end. So I'll be happy to ask all of those questions at that time.
Wonderful. Thank you, guys. All right, so I also want to bring up state property taxes because many of you probably heard about Prop 19, which came into effect maybe 3 months ago and really changed the tax landscape when it comes to state property taxes. This is a California state property tax only. And the prior law was that we had the parent-child exemption for the primary residence. If you pass the house down to your child, then they essentially get your state property tax bill with no reassessment. And you are able to give an investment property and exclude $1 million from the assessed value for your child, so that while state property taxes could go up for the child, usually they don't because of that exclusion. Prop 19, we kind of lost that. For investment properties, that exclusion is lost entirely. For the primary residence, now instead of a full exclusion, we are given a $1 million kind of coupon to help our children when they inherit the property, but they only get that coupon if they choose to move into our primary residence after we pass. So it's important to, the time has kind of elapsed where we could prevent this problem. There was a big rush to do all sorts of irrevocable trust planning at the end of last year. Now it's more just counseling you so that we can prepare for this reassessment should it occur and make sure there's enough liquidity in the assets you pass down so that when the state property taxes do increase, we're not forcing your child to sell the home. There's a plan to pay that increase so that they can stay there to match your intent. Zeb, is there anything you wanted to add about property taxes?
Yeah, there's a lot of potential ramifications for mobile home park and RV park owners with these changes. To simplify the exemptions that we used to be able to use before February 15 of this year, before Prop 19, are gone. And with many mobile home parks and RV parks, especially if there's a ground lease and the like in place, it may change the economics or the profits of the park. I had one client that at a death event, the property taxes could have gone from $100,000 a year to $600,000 a year. It could have been a major change in property tax. So we ended up fighting in court actually and got it knocked down a lot. But for all of the people listening, if you have any questions on property taxes, there is still some planning available that involves the use of entities like partnerships and LLCs. But really think about that because that's a super important tax at a death event that might change and become a lot higher for your heirs. So if for no other reason today, really think about emailing Andrew if you have questions about that.
Thank you, Zeb. I've also been asked a lot recently, what are the proposed tax changes for the future? A lot of people are concerned about the Democrats being in control, and are they going to drastically change the tax laws as they sit today? So again, the previous slide is the laws as they exist right now. Here are some proposed changes. First, I want to highlight this is not a proposed change, this is the planned change. The $11.7 million estate tax exclusion that we have now, that is set to end January 1, 2026. And if no other legislation is passed, it's earmarked to fall to $5 million per person, $10 million for married couples, okay? And then we are expecting it to be adjusted for inflation. So in reality, it'll be a $6 million estate tax exclusion per person, or $12 million if you're married. The current proposal is to lower this to $3.5 million per person, or $7 million if you're married. So again, this is the estate tax and gift tax unified exclusion. And the current law is that they are in fact unified. So let's say the current law is $6 million exclusion, and you gave a $2 million property to your child tomorrow while you're alive. And then when you passed away, you gave that same child $4 million of inherited property. Great, no estate tax, no gift tax. We fully maximize the $6 million coupon. We're fine. But there's a proposal right now to de-unify the gift and estate taxes and to drop the gift tax exclusion to $1 million. So what would that look like? Well, if you gave that same $2 million home to your child while alive, then you would be gift taxed on $1 million. And that gift tax would probably be a 40% rate. So again, this is just a proposal. This is not the taxes as they sit today. That is what's being talked about right now. In addition, capital gains tax, the current law is to get that step up in basis. So remember that example where you bought that house in 1970 for $400,000. It's now worth $1 million, and you pass away and you give the house to your child at a stepped up value. So instead of getting capital gains taxed on the $600,000 gain, now your child can sell it immediately with no capital gains tax at all. That is the current law. There is a proposal to eliminate to get rid of that basis step up and essentially have a full capital gains tax as soon as the ownership is transferred from the parent to the child. In our opinion, these proposals, and Zeb, correct me if I'm wrong, but it's certainly my opinion, I think it's yours too. We don't expect these proposals to pass. We think that the political landscape is such where we think that these drastic changes are unlikely. But if you want to engage in planning now, where the laws are probably more favorable to you in case these do change later, of course, please email me. I'll bring it to Zeb as well. We'd be happy to work with you. Zeb, is there anything you'd like to add on that?
No, that covered it pretty well, Andrew. I agree that it seems that the political winds are such right now that some of these more extreme changes may not come into law. It's changes in the tax law. The big one that a lot of people are worried about is losing the step up in basis at death. That would be huge for anybody listening in right now, because there's often a lot of appreciation in the real estate for any RV park or mobile home park owner, but it seems unlikely. We would just view it as, I think at the moment, more of a wish list that people should pay attention to. And if they're doing any high-end estate planning, meaning planning that is motivated to save tax, make sure it's flexible. So again, when you email Andrew or whatever and get started on that planning, ask about, hey, how can I have a flexible estate plan? So if there's law changes, is this plan good enough to withstand those?
Thank you, Zeb. Moving on, we wanted to tailor this discussion to our primary audience, which of course is RV park and mobile home park owners. And it's very important to customize the estate plan for your particular needs because a lot of you have family-owned businesses. It may be family-owned where it's all owned by a husband and a wife, or it could be owned amongst several siblings and their families, or it could be co-owned where two different families are involved or two different friends are involved. Each of those scenarios require different planning. So please reach out to us and we'll run through all the facts and make sure we tailor the estate plan to fit you. The other factor to consider is the different sizes of the estates, the different values. So we'll call it that, let's say the standard park owner has a park worth $10 million or less. The medium size is $10 to $20 million. And then the large is $30 million or more. I know we've seen RV and mobile home park owners exceed a company of $200 million. So we want to make sure that we customize this to fit your specific needs. So first we'll talk about the standard owner. You need a revocable trust to avoid those probate court expenses we were talking about earlier, and also to ensure proper management of your company upon your incapacity or upon your passing. We also recommend an LLC. Obviously, there's many corporate structures out there. The S corporation is a very popular corporate structure. For you, we recommend an LLC. You have liability protection with an LLC. There is less annual maintenance for an LLC. And because your business is essentially owning real estate, it'll be a better tax position for you if you do it under an LLC rather than a corporation. The exact reasons why are going to be beyond this presentation, but of course, email us and we'll be happy to answer that for you. We also want to take
Andrew, sorry.
Yeah.
There's maybe one exception, which is some mobile home park operators and RV park operators have a company that just handles park operations. So it may have employees and the like. And on occasion, if it is just for the operations, it might be a good idea to have an S corporation. But otherwise, I agree, to own the park itself, you almost always want like an LLC.
Thank you for that. Do you want to go into why we'd want to review their lease agreement as well?
Yeah, well, and I'm sure Dan can give some input too, but when mobile home park owners or RV park owners talk about, hey, how can I best limit my liability if the park gets sued? That lease agreement with the tenants is your first line of defense, I call it. In a well-drafted lease agreement it's usually I call it the pad, the piece of dirt on which the RV or the mobile home park sits. It's critical because with any liability that comes up, the litigators go through that line by line. So if nothing else, please get your standard lease agreement reviewed by a knowledgeable attorney. Honestly, myself, I don't specialize in that, but we recommend that's a great bang for your buck. We realize there's a cost to get lawyers to review leases, but it's so important that we really recommend spend the money to get that done, and also have good property insurance on top of that.
This is Dan. I would just echo what Zeb is saying. Whatever your politics right now, in this time period in California, there are just a lot of COVID, a lot of rent control, a lot of moratoriums. There's just a lot of laws that are getting passed to protect tenants, our customers, and are taking away a lot of property rights. And we can have a discussion outside of this webinar about whether we should do more in the courts or whether or not we should do more with lobbyists. But one of the things you can do right now for your park is get with your attorney, and as Zeb says, you can put as many contractual protections in your contract as sort of a way of exercising control over this tremendous asset that's worth, $10 or $20 million.
Thank you for that. Absolutely. And in addition, life insurance is very, very important. We'll kind of go into that a little later, but essentially for liquidity reasons. We'll talk about that in a minute. Now, for our medium RV park or mobile home park owners, you'll need kind of all the above. You'll need the revocable trust, review the lease agreement, review your insurance policies. We'd also recommend that instead of one LLC, you get two different LLCs. You should have one LLC for the management function of your company, and then the other LLC should own the land. Why do we want that? It's a method of compartmentalizing and limiting your liability risk. So if one LLC manages all of your employees, should one of the employees sue you, they're only going to be limited to the assets in that management LLC. They won't be able to touch the value of your land. Vice versa, if something should happen to your land, slip and fall, or I don't know. I just saw an article on Canyon Lake. There was a fire and 40 RVs were lost in the fire. I imagine that we might be seeing a lawsuit against the owner for that fire. Who knows? But we want to be able to limit the liability to, if it's a action against the land, limit the liability to just the land. If it's an action by an employee, limit to the company who's managing the employee. And then you can do lease agreements where one company's leasing the land from the other, or the other company's leasing employees from the other. There's all sorts of fun ways to play with it. We can limit your liability by doing that. And also, I want you to take a look at your workers' compensation coverage and health insurance needs, because as you gain more employees, those needs will increase. And then the Irrevocable Life Insurance Trust, also called an ILIT, very important once you start developing significant net worth. And the way that it works, life insurance is almost always income tax free, but it is still subject to a state tax unless you place it into an irrevocable life insurance trust. We're going to take our most likely future scenario reminder in 2026. We think that the estate tax exclusion will go down to 5 million, but then be adjusted for inflation. So it's at $6 million and it'll be at a 40% rate. So we're going to use that for the following examples. But assuming that's what it's going to be and no changes in the tax law, And look, I recognize these are very simplified examples. No one here has $7 million of real property with $0 in the bank. You know, obviously, you all have investments and retirement accounts and money in the bank. But just for ease of math, if you have a $7 million piece of real property and nothing in the bank, then you'll be subject to $1 million of estate tax. Well, 40% of $1 million at your death means $400,000 just lost to taxes. And it raises the problem, how do we pay $400,000 without selling the land? Because the land's the only asset you would have at that point. So, or we do a $6 million, so we have real property that's worth $6 million and we get a $1 million life insurance policy and we pay that to the spouse. I see that very often, particularly with smart people who did not hire an estate attorney. They at least had the foresight to get life insurance to help out their spouse. Okay. The result is you're still going to lose $400,000 to estate taxes, but at least you have the $1 million policy to pay for them. But there's a better option. We can do an irrevocable life insurance trust for you. So now we have a $6 million piece of real property. We have $1 million in a life insurance policy held in ILIT. No income tax, no estate tax. You save $400,000, and we have a $1 million life insurance policy to pay any expenses that may accrue. Maybe there's a different tax that applies, or just there's some debt to the company, or all sorts of things can happen. We want to make sure you don't have to sell a part of your business or sell a part of your land in order to account for any expenses that may happen after you pass. And then for our large net worth clients, you need all of the above: the revocable trust, the ILIT, 2 LLCs, or possibly more. And then we want to engage in some Prop 13 planning, because state property taxes are going to be a concern for you. When you pass away, we should expect a reassessment on your real property. And more than that, for any owner of a commercial building, or all of you who own these parks, you're not living there. And when you don't own it outright, if you have a loan with, say, a bank, almost every bank is going to have what's called a due on sale clause. So if the ownership changes from one person to another, which will happen at death, right? They have the right to immediately call the full value of the loan. Could be 400,000, could be 7 million, who knows? We don't experience that in our day-to-day life because there's the Garn-Saint-Germain Act, which makes it so that they cannot use a due on sale clause when we sell our house, or basically any residence. I believe it's anything under 4 units is protected. But for you obviously have large pieces of land with many units on it. So I think this is a direct concern for you. We're going to want to guide you through so you're not surprised. And then there's also some very advanced techniques I want Zeb to really get into the details of, but well, Zeb, do you want to talk to them about discount planning and estate freeze planning?
Yeah, sure. So for the large or substantial RV park or mobile home park owner, when you get over whatever the exemption amounts are, whether it's 6 million a person or 12 million a person, double that for couples, the government is going to get 40% of everything above that. So if you have a very substantial, if anybody listening in has a very substantial mobile home park that's worth $50 million, the exemptions are roughly 24 million. So that would leave 26 million subject to estate tax at 40%. I don't have a calculator in front of me, but I think that's 8 to 9 million off the top of my head of estate tax. If you're able to use discount techniques, and I'm not going to get into too much detail on these discount techniques, but basically a discount technique means you're using an entity, which you should be, like an LLC or a partnership. And over time, you're gifting entity units like membership units in an LLC or partnership units in a partnership. you're gifting that over to your children, or more likely to an irrevocable trust for your children over time. And estate planning attorneys love to break assets into pieces, like a mobile home park into pieces of membership units, because the pieces never add up to the whole when you get them appraised. So just to use a round example, if you have a $10 million park and 10% you might think is worth $1 million, but if you give away 10% of an LLC that owns a mobile home park, when you get the expert appraisers in there, they actually say, no, that's not worth $1 million. It's really only worth 600,000. So you're making value disappear on paper. The IRS doesn't like these discounting techniques because they know they're losing money. Congress is not thrilled with these discount techniques either because they know they're losing money. And in fact, one of the bills coming out this year is trying to get rid of discount planning. But for now, it is the current thing that people can do. And we describe it, Andrew and everyone, as use it or lose it. So you either take advantage of these techniques while they're around, or you lose that ability. But again, just to use a round number, a $50 million home park, and you do a lot of good discounting on that, you might be able to shave 10 or 20 million off the value on paper. If you save 10 million in value, that is, you've just saved your kids 4 million of estate tax. So discount planning is definitely an arrow that we want to keep in that quiver, keep it going for now, for things that we can use for tax planning. Estate freeze, go ahead. Is there a question? I was just going to say then, estate freeze planning is similar in that what you want to do, for all mobile home park and RV park operators, especially if you've got something that's going to be around a long time, inflation is going to be your worst enemy for taxes. I can't tell you how many times I've seen an RV park owner or mobile home park owner, and 20 years ago, the park was worth $5 million and now it's worth $15 million, for example. There's a lot of inflation with values for mobile home parks. If you can get a mobile home park at that 5 million range and do a freeze technique, again, outside the scope of this, but a freeze technique means you're going to lock in that value at 5 million and have the appreciation go outside of your estate. That difference between the 5 million and the 15 million is going to be outside of your estate, and there's no estate tax on that. And you just saved your kids another $4 million. So discount planning and estate freeze planning need to be looked at very carefully with high net worth mobile home park and RV park owners. That's my little discourse. I'll let you jump back in, Andrew.
Thank you, Zab. Appreciate it. Moving on, and I'm going to move a little quickly as I want to make sure that Dan has time to present too. But as we kind of alluded to earlier, we can write the best trust in the world for you, but if your assets aren't in it, it's not going to actually help you. And I like to, obviously, why is there a cereal box on here? I like to describe a trust like a box of cereal. Your financial assets, your LLC, your bank accounts, your real property, everything, that's cereal, right? We want to make sure it goes into the box. The trust is the box of the cereal. Right now, it's in your pantry. You're in full control of it. If you need money, you can pour yourself some cereal and use it for whatever you want. But eventually, you're going to pass away. And then at that time, it's still your cereal. It's still your box, but it's going to be in the pantry of a friend or a family member. And now they have to follow the instructions on the box. They don't follow your instructions, they can be held personally liable for any mistakes or any foul play that's involved. But what I find most of my clients, the cereal's not in the box, it's strewn all over the counter. A really good example is if your business is in an LLC, did they put your LLC into your trust? Okay, there's a right way and there's a wrong way. We don't want to just write an assignment to put it in there. You need to check either the bylaws or the operating agreement. Bylaws for corporation, operating agreement for LLC, and make sure that the bylaws or the operating agreement actually allow for the company to go into the trust. Many don't. So you need to make sure that you have an estate planner who can do business law as well and review that. And then if it's a corporation, we need to reissue stock certificates, update the stock ledger, et cetera. If it's an LLC, we need to make sure that it's not just an assignment, but also the LLC is drafting an acceptance that is in line with the rules of the operating agreement. So please don't fall into a sense of false security. Get this looked at by several pairs of eyes. I also want to talk about business annual compliance. We all, have those yearly statement of informations that need to be filled out, or maybe it's every 2 years. But annual compliance is so important. You got to pay that $800 franchise tax board fee if you have a corporation. Do the minutes every year, or have an attorney do it for you. Have the stock certificates be filled out. Don't be like this person who has their company suspended. If your company is suspended by the Secretary of State, you cannot legally transact business, you can't enforce contracts or defend yourself in court, and you shouldn't expect any liability protection at all if you get sued. So these are basic concepts, right? But I find they're very much missed, and I don't want you to fall for that. And then just Zab, I'm gonna turn it over to you for the rest, and then we'll make sure that Dan can talk after that. And it's been a real pleasure presenting today.
Thank you, Andrew, and everyone. Yeah, I'll try to go through this pretty quickly. We've talked about some of these things. So use an entity to limit liability. You definitely don't want people that own units, or people like mobile home parks and RV parks. There's constant traffic in and out, a lot of people on the property. Limit your liability. Use a good lease form. We talked about that. Use techniques like liability insurance. Definitely use someone like Dan or a good litigation attorney to help look at your insurances. That's your second line of defense with a lot of litigation. You want to transfer that risk of litigation to the insurance company. Use a living trust to avoid probate. For any person listening, especially if you have business partners, you also want to think through what happens at a death event. Who will actually run the property? Some mobile home parks want something called key man life insurance, because if you're the one running the park and you pass away, whoever your heirs are may have to hire somebody to step into your shoes, and there's a cost for that. So you may want to get some life insurance for that. It's called key man life insurance. I just put in here, a lot of people get worried about property taxes. We've talked about that. Please make sure somebody looks over what happens with property taxes if I die. And then I've had other client situations where if it's a family-run park, families, I know none of your families will do this, but I'll just say my family, we've known to have the occasional argument at Thanksgiving or whatever. So occasionally families do argue over who the best one is. And I found that the best transitions is when the families talk about it ahead of time. Don't wait until it's too late to plan out who's going to be running the park. I don't have control of the slides. So what's the next slide? Can we move it to the next one? Thanks. Again, planning considerations, use that living trust to avoid probate. Consider using multiple entities. Each entity creates a compartment of liability, and you want to limit your liability to that compartment. But see Andrew or Dan about setting up those different compartments. Unfortunately, in California, it's $800 per year per compartment. So there's you have to make a business decision. How many compartments do I want? And again, we've talked about these other things. Save all these taxes and get that step up in basis at death if you can. Your heirs will appreciate it because they'll be able to sell the park without capital gains tax, and they get increased appreciation. What's the next slide? Business succession planning. So in addition to doing all these things that will avoid probate, your RV park and mobile home park is a business, and you want to think through those details. If I die, who's going to be actually writing the checks? Who's going to be hiring or doing the leases? Who's going to be hiring the people that work at the park to clean it up, or maintenance people, or and the like? So you want to think that through and make the provisions in either your agreements, because your LLC agreement can have some provisions about that, and your trust can have some provisions about that. Where unfortunately we've seen a lot of situations where the families do not do that kind of planning, and then it goes into litigation mode and it just gets very, very expensive. And we say it jokingly, even though we're all lawyers here, nobody really wants the lawyer to be a beneficiary of mom and dad's estate. We really want it to go to the kids. So trying to avoid those disputes is a great way to do that. Next slide.
Yeah, perfect.
Jump in for Andrew, do you want to take this?
Yeah, I just want to introduce, obviously you all know Dan, but Dan, thanks for letting us present today. That's our topic. We want to turn it over to you.
Thank you guys so much. That was an excellent presentation. And I know the members are going to find all this information really valuable. Thank you so much. So let me just, in the last 10 or 15 minutes that we have, I can just sort of do what Zeb was talking about just some of the basics. I was trying to put together a PowerPoint that would just dovetail nicely with what Andrew and Zeb were talking about. And I thought, well, from my perspective, let's just go over some of the basics of what you should do to get your RV park in good shape. So obviously, sometimes I have clients that didn't realize that they have some spaces in the back of the park that were vacant. So obviously, sit down and do a serious audit, if you will, of your park. Go through and make sure that if you have vacant spaces that you wanted to get rented, that they're rented. Make sure that your rents are to market. I know sometimes I have different clients where the mom and pop who have owned the RV park for many, many years have not raised the rents in a long time. You're going to want to try to get your rents up. And it's just going through the basics, which is, well, how do I know what market is? How much should I raise my rent? You can do things like an informal rent survey. You can call around to your competitors, your other RV or mobile home park properties in your area. Find out what they're charging for rent. Some clients don't know what market is or can't get a handle on a range of what market is. Some of my other clients are very sophisticated and know what rents are. Once you kind of determine what market is, then work with your attorney or your professional property management company, know how to implement rent increases, know how to properly serve rent increase notices. Like anything during COVID, even the amount of notice you give gets a little complicated with the new rent COVID moratoriums. Mostly from a liability standpoint, your RV park attorneys and mobile home attorneys will caution you to raise your rents gradually, because if you raise the rent too much at one time, your residents are going to go berserk and they're going to hire a lawyer. They're going to go to City Hall. They're going to demand that their city council members adopt rent control. We've handled litigation just like that. We've handled an RV park up in Northern California where the park owner did implement something like $100, $120 rent increase, and it triggered right away a lawsuit. It's not to say that the lawsuit had merit. The lawsuit really didn't have merit because there was no rent control. But the point of it is that it took a lot of time and money away from the business to even defend the bogus lawsuit. So you want to be careful when you raise rents. You want to do it gradually over time, generally speaking. You don't want to trigger any type of adverse reaction like litigation. Oh, let's see. I'm pressing toggles here and that didn't work. Let me see if, oh, there we go. Take this thing out. So also getting into the weeds in this, and I'll kind of finish up here in a couple of slides, is I'm also wanting you to protect your asset. I'm wanting you to actually perform an audit of all of your tenant files or your resident files. I can't tell you how many times that someone asks me to evict someone and I ask them for the rental agreement and they don't have a rental agreement, or they have the rental agreement with the tenant's name on the front page, but the rental agreement is not signed. So go through your tenant files. That may, if you have a very large park, that may take some time to go through, but you're really doing an audit of your own tenant files. You're looking at that tenant file, and I've done it where I've come out to a park and sat down with the park manager and looked at your rent roll, looked at your names on your rent roll, and then say, okay, let's look at your rent roll and look at space one. It says that Sally Smith is living in space one. Now let's turn to your tenant file for space one. Let's open up that file. What do you have there? Well, we have this rental agreement and it doesn't even say Sally Smith on it. So it's like, okay, well, we're going to need a rental agreement that says Sally Smith, and we're going to need Sally Smith to come down to the park office and sign it. So you want to go through and audit your own files. You also, as the laws change, if you have registration agreements at your RV park that are 10, 15 years old or 5 years old, and you have rental agreements that haven't been updated in 10 or 15 years, and you have old sets of park rules, you're going to want to come to someone like my law firm or another RV park attorney, and you're going to want that attorney to look over your registration form, your rental agreement, and your park rules. Currently, California law does mandate that you have some of these agreements, like a registration agreement, and it mandates what needs to be in your registration agreement. And then other agreements are more optional, but more and more lately, I see more RV park owners who have really long-term residents. I mean, RV parks where people have been living there in the park for 3 or 4 years. When you start having really long-term residents, it's probably a good idea to go back and say, well, we probably need a more thorough rental agreement so that from a contractual standpoint, we can govern these long-term residents because they're going to be in our park for a very long time. Update your park rules. What does that mean? Well, it means, yes, sometimes the law changes. It means sometimes the attorney's latest and greatest thinking about what should be in your rules is now changed over the years. And basically it means, do you have a lot of rules in your park rules? And it's not just to give the attorney a lot of work. We do a fair number of evictions where the client comes to us and says, Dan, I want to evict this person because they are doing graffiti because they're just kind of crazy people, crazy kids, and they're doing graffiti on the wall next to the pool area. And it's like, great, we can do that. Why don't you give us a copy of your park rules? And we look at their park rules, and of course, there's nothing even about graffiti, but there's also no park rule about not damaging the common areas. And so then we're coming back to the client and saying, client, you would have a much stronger case in court if you had more extensive rules, at least rules that covered things like don't damage the common areas. That's something as lawyers we could hang our hat on with this graffiti on the wall in the pool. So that's what we mean, sometimes what we mean by more extensive rules. We want a lot of rules so that hopefully when, unfortunately, once in a while you have a resident who's has bad behavior, we have some type of rule that governs that, so that the lawyers have a way of dealing with that resident, and if necessary, removing them from the park. Oh, I keep doing that wrong. Let me go this way. I'll do that. I think I have to go that way. Okay. We talked a minute ago in one of Andrew's PowerPoints. He said, leave your business to the next generation gradually. And I wanted to dovetail on that because I do have some clients that have multi-generations managing different parks. And I thought that we should mention that it would be a good idea if you've been running your park for 40 years and you have your 20-year-old grandson who's going to be learning the business, or granddaughter, send your grandson or your granddaughter to management courses. Take advantage of those management courses, educate as much as possible. You may think that you're going to be able to do all the mentoring and all the training of your next generation yourself, and that's certainly true. But there's always something new to learn in this industry. That's why I enjoy being a lawyer in this industry. So send your kids, send your grandchildren to any type of management courses that are being offered. And on this slide, Diana Kelly and I wanted to remind our Camp Cal Now members that Camp Cal Now will soon be offering a very comprehensive management training course. I think it's slated to start perhaps later on this year. And so take advantage of your benefits as a Camp Cal Now member and attend these management courses. I think also, of course, have the proper employment agreements prepared and signed between you and perhaps your park manager. The legal relationship between you and your park manager is often an at-will employment situation, and you all often give your park manager housing or free housing or a free RV or free mobile home as an incidental to their employment. You want to make sure you've kind of got that all documented correctly. We do occasionally have issues that come up when, unfortunately, managers are terminated, and we have the issues to deal with regarding that free housing. Going on to the next slide, maybe, thank you. Also, actually, Andrew reminded me, I should include a slide about protecting our clients' asset and having our parks inspected for ADA violations. We mean ADA, we mean the Americans with Disabilities Act. And Diana Kelly has had me on previous webinars where we've talked all about ADA inspections. So the basic idea here from a lawyer standpoint is that you have an RV park, and that RV park has certain blacktop parking areas, handicap parking. You have certain wheelchair ramps from your parking spaces up to the sidewalk. You walk into the park office. You have issues regarding the countertop. Is it the required height, or is it too low or too high under the ADA? There are, unfortunately, as a cottage industry, there are a lot of plaintiff law firms with their whatever straw men, their plaintiffs, and actually a lot of plaintiff lawyers, I guess, that are looking at your parks even on Google Earth, and kind of figuring out that, they can tell that you are actually in violation of the ADA. And suddenly you're being sued with a lawsuit for the Americans with Disabilities Act. They're somewhat difficult to defend, because if the ADA said that your parking space is supposed to be so many feet wide and yours is not, then they've kind of got you dead to rights. And then they try to, essentially shake you down and ask you for $10,000 or $20,000 or $30,000. So my law firm is affiliated with MHRV ACE, and that's the website. You can go on there and get one of our CASP inspectors to come out to your park and do an inspection of your park. And then our CASP inspector, his name is Jason. Jason will give you a very nice report that's very comprehensive, that explains to you, what's wrong with your park, or what parts of your park are in violation of the Americans with Disabilities Act, and what you can do to get those things fixed today. Because you don't want to not fix it and get sued in an ADA lawsuit. You certainly don't want to just walk around and ignore that and leave that as a big problem for your children when you're turning the park over to your children. So something to think about in protecting your asset. Next slide. There we go. I think beef up on insurance. We already talked about that for a moment. I think I was just Googling what Andrew was saying I'm not sure if it's a storage facility or not, but I did see that there was 1 or 2 days ago a fire at Canyon Lake, California. It's saying something about 30 to 40 motorhomes or maybe RVs that were burnt to the ground. So these things happen. We know it happened from the fires that we have in Northern California. So make sure that you've really beefed up on insurance. Make sure you have insurance that protects you from a failure to maintain lawsuit. Make sure you have the right insurance in case you're sued by your employees. Damian Petty is one of these insurance brokers that specializes in RV parks. He's actually an RV Camp Cal Now member. So make sure that you're getting with Damian or someone else and you have the adequate amount of insurance. I talked to Damian before this presentation. I asked him, what should I tell everyone on the webinar? And he said, well, people should just really budget for insurance, get the right insurance, figure out how much it's going to cost. Sometimes he sees that people die and their children are saddled with this increased cost and expense on insurance that they didn't know they were supposed to have. And suddenly the finances look a little bit upside down at the park. So next slide. And then finally, I think, well, this is my last slide, just keep informed. Utilize the benefits that come from being a Camp Cal Now member. If you're a Camp Cal Now member, you're going to be getting periodic emails from Camp Cal Now. Read them. They're trying to, Diana and her staff work really hard at every day knowing what's coming down the pike and trying to keep you informed as to what the latest is going on and how you can make your park more prosperous. Attend webinars, utilize the Camp Cal Now legal hotline, and she also, at Camp Cal Now, we have a ADA hotline, so take advantage of those benefits. Keep good professionals on retainer, as like any business owner would, good CPAs, good estate planning, and try to just keep abreast of what's going on, especially this past year when trying to evict RV residents. It's been a very tricky road, as everything has been tricky during COVID, but it's been a little bit tricky to know exactly what the strategy should be to evict RV residents, for example, under the federal and state COVID laws. There's actually, some of those laws affect us and some of those laws don't affect us. And I was just putting this last bullet point that some of the laws are requiring us to state cause in our eviction notice, whereas for the last 20 years, we didn't have to state cause in some of our RV tenant eviction notices. So it's just one of my examples. I think, Chris, if you're our IT guy who's monitoring this, is that the last slide? I think that's the last slide. So maybe Diana, if you wanted to hit Zeb and Andrew with some questions, that would be great.
Yeah, thank you, Dan. This is actually Rachel. I'm one of Diana's staff members over here at Camp Cal Now. She had to step out for a call at 11, but I've been on the webinar and I have all of the questions and answers open. So if it is all right with you guys, I will go ahead and jump in. Also,
Sure.
Hello, everyone. So the first question in the Q&A box, it looks like, is, what is the rationale for the court to not include debt when calculating the value of an estate?
It's a great question. And I'm sure Zeb has his own opinions too. This is Andrew. My personal opinion is to incentivize you to go get a trust. I think something like 80% of us passed away without a trust, and the courts are overwhelmed. And I know if I was a legislator, I'd want to, I guess, penalize people for not doing planning ahead of the time, because the courts are just simply overwhelmed by not including the loan when calculating the fees. Of course, it results in a higher fee, and it allows more of an incentive to get the right planning done. Is there anything you would like to add to that?
Yeah, I think if I understand the question correctly, what's the policy behind that? And there's no fees or taxes that make any policy sense to me whatsoever to begin with. It's just the government does it because they can, and they charge the fee whether you've got debt on a property or not. So, try to avoid probate, as Andrew said, or keep the debt down. Debt is handled separately in probate. Probate is a protective device to make sure creditors get paid. But there's no rationale to the public policy behind the executor fees, as far as I know.
Okay, perfect. Thank you for that answer. The next question was in the chat, and that one is, does an LP work just as well as an LLC?
Did you want to take that, Andrew? Or you want me to?
No, go ahead, Zeb.
It does. In general, it does, except I apologize because it's a little complicated. With a limited partnership, one of the partners always has to be what's called a general partner. So the general partner still has unlimited liability, and so that's not good. So the exception would be a limited partnership works as long as you do something like have an LLC as the general partner. Why would you want to do that? Because you sort of have two entities rather than one. And two entities, by the way, in California means it's $1,600 a year instead of $800 a year. Well, the reason is because with an LLC, LLCs pay a thing called the gross receipts tax. If any of the people listening in know what that is, but it's basically a fee. If your park is fortunate enough and has revenues, over $1 million a year, so some pretty high revenues, you can get into a pretty high, not a high really, but the gross receipts tax in California caps out. It ranges from between $6,000 a year, let's call it, and $13,000 a year. I'm greatly simplifying it. And you actually can avoid that tax if you have a limited partnership with an LLC as the general part, like I call it the 1% general partner. You can avoid the gross receipts tax. So, but they're in many ways, the limited partnership and the LLC are very much the same.
Okay, thank you for answering that one. It looks like the next question is the CAR lease good for parks?
Sounds good. Dan, you want to jump in on that one?
California Association of Realtors, I would say, generally speaking, is that a good idea to have that lease for your RV parks? I would say no, it's not. It's designed for, I think more for apartments, and that's stick-built apartments. And our industry is not stick-built apartments. It's a unique situation where we own the real estate, or as Zeb says, we own the space or we own the pad. And they typically, not always, but typically they own their RV. And this unique relationship where they own the RV, but we rent them the pad and then give them privileges to go use the clubhouse or use the pool. That's a very unique, situation, living arrangement. It's not just renting someone an apartment. And there's some big differences, obviously. When you rent someone an apartment and then you evict someone from the apartment, they basically can take all of their clothes and their couch and their furniture and they can get the heck out, or they can be evicted and get the heck out. But of course, we have the situation with, RVs that are really old. RVs are people's homes. RVs are broken down. They can't easily be moved off the space. And we have a different set of law than apartment rentals. Apartment rentals are basically governed by what we call in our office regular landlord-tenant laws, whereas an RV tenancy is governed by the recreational vehicle occupancy park law, or we call it the RV law around the water cooler over here, just for short. So you really need an RV rental agreement, an RV registration agreement, because that's what the law requires under the RV law.
I would add to that on occasion I've seen people use something like the CAR lease, as long as you have maybe an attorney reviewed, I'd call it an addendum, So sometimes we see these things with an addendum, which is like maybe 5 or 10 pages long, because you may need quite a bit of stuff in the addendum. But I would entirely agree. Don't use the CAR lease without having a lawyer, work with you, either doing an addendum or use the lawyer's lease form, because these are very specialized leases, like Dan said.
Yes, thank you, Dan and Andrew. I know we do have some forms and documents like that available on our website, on the Camp Cal Now website for our members. So if anyone has any other questions about forms and documents, you can always call the office and we can help you out or send you across the legal hotline. And the next question might be a little bit more appropriate for the legal hotline. So Dan, just let me know if I should send this off to you offline. The question is, how much evidence do you need to give someone? How much evidence do you need to give someone a notice for dumpster diving?
Well, please fill out the legal hotline form, or Rachel can give that to me and I can talk to you offline today. But let's just use that question as a learning experience. What we're talking about is that people live at your park, they walk around your park, they engage in bad behavior. And you need to perhaps give them a warning notice. Sometimes you want to give them what they call a 7-day notice. Sometimes you have to give them a 7-day notice. Sometimes you don't. And you want that 7-day notice to identify a park rule that they're violating. And in order to make it look really good for the judge, because at the end of the day, I only care that the judge is going to rule in your favor. You should explain to them in the 7-day notice what they should do to remedy the park rule. And then what judges really, really like, and what you should have, is you should have a proof of service attached to the back of the 7-day notice. So the judge can see with the proof of service, when you served them with the notice. In terms of evidence, that's something that we should all keep in mind, that lots of times park managers didn't actually witness with their own eyes the bad behavior. And judges, even under the very laxed or low evidence rules in an unlawful detainer trial, judges still want people to testify only to what they saw with their own eyes. And that can be a real problem with park managers, because park managers are in their office, they can't be everywhere. One of the residents comes into the park office and says, I saw someone else, another resident down the street, do something bad. Well, what does the park manager do with that? And so we can work with you about putting together the proper warning notices that say things along the line that, that other residents have witnessed this. And then the park manager should follow up with the problem tenant and try to see, with their own eyes, the bad behavior. So I hope that answers your question. It's a good question. The question is what kind of evidence do we need if we want to take the appropriate steps to issue rule violation notices and go to court? And oftentimes, I have files in my office where the park manager says, well, I think this happened. I'm not quite sure. I might be speculating, but I just think that based on rumors that someone on the other side of the park is doing something wrong. And we counsel our park managers that that's probably not going to pass muster with the judge. The judge is going to want something a little bit more than you speculating about something for that judge to issue some type of ruling in your favor in court.
Okay, thank you, Dan. It looks like we have 2 more questions. It looks like people are starting to drop off a little bit, but the next question is, please elaborate on the discount planning. If the property is already owned in an LLC with multiple partners, what more needs to be done to lock in this non-control discount?
This is Zeb. I'll jump in for that. That sounds like a good start for where you already, that whoever that owner is has some good discount planning already in place. Because if I'm hearing it right, if they own what I'd call a minority, so less than 50% position in an LLC, at a death event, there should be some good discounts available for that ownership position. What discount planning, maybe combined with an estate freeze, might look like for that person is I would normally like to be, if you will, like proactive with the planning and do some gifting of that, some of that position now. And again, outside the scope of this, because you can gift or sell, but do some of this while you're alive, because you can get a gift return on file with the IRS. They usually don't audit gift returns because there's not a lot of money in it for the IRS with these gift returns. And you get that discount locked while you're alive. And if the IRS questions the discount, you're still around to help defend all that. Or you could wait until death. So every situation is different. And again, it gets back to whoever that is should see an attorney. But discount planning can work both during lifetime and at death. And whoever asked that question, if you own a minority position in an LLC already, your family is going to get some discount effect already.
Thank you, Andrew. Okay, it looks like this is our last question. And this question is having a different LLC as a 1% member good legal protection?
This is Zeb again. Yeah, that maybe relates to if you have a 1% LLC but happens to own what I call 100% of the general partner position in a limited partnership, then that is good. That will work. So as long as the general partner position is protected in an LLC, you have created a successful liability compartment where the liability is limited to within that partnership. An LLC on its own is also good asset protection. It's like having a corporation. As long as you have a good entity that's keeping good books and records, and there's a thing that we lawyers call piercing the corporate veil. As long as you're avoiding those things, they all provide good liability protection.
Perfect. Thank you so much, Seb. So I think that is all the questions we have for now. If there are any other questions, anyone can call the office and we'll do what we can to help you out. If anything, we'll get you in touch with our legal hotline program. Go ahead and, as long as there's no more questions, stay on. There's going to be a brief poll after that really helps us in planning future webinars, both with Dan and with some of our other supplier and attorney partners. And if you would like to share this link with anyone, or if you need to, save it to review again at a later time, it'll be available on our website next week. So thank you, Andrew and Zeb, and of course, Dan and Chris.
Yeah, thanks, everybody. And I'm going to launch a poll right now. Thanks for everybody's participation and for all the hard work that went into making a great webinar.
Thank you for the invitation, Dan. Zeb and I very much appreciate it. And everybody who's participating, Dan is a fantastic lawyer. Hope to make a connection with you as well. And obviously our phone numbers are right there. Don't hesitate to call if you need us.
Thank you, guys. This is Dan. I appreciate it. Really good webinar. Thank you guys for the hard work that went into putting all this together, and I thought your PowerPoint was excellent. So everyone, please do give us your feedback on the poll, because we want to improve our webinars in the future. And everyone have a great weekend. Bye-bye.